Thank you, and good afternoon. I'm very proud to be your new president. And first off, let me tell you something which may have escaped you. It's APIL's 25th anniversary year. We've come a long way, and it's testament to so many people that we are still here today, still fighting the good fight, still righting wrongs for those injured and harmed through no fault of their own. I cannot stand here in this year of years and not recognise the immense contribution of our past presidents, executive committee members, group coordinators and secretaries, and indeed all our members who have supported the organisation. It's wonderful that so many of you are here today to help us celebrate. Some deserve special mention. First, John Spencer, who today becomes our immediate past president. And second, Deborah Evans, our chief executive. From a personal perspective, this last year must have been the worst imaginable for them and their families. John tragically lost his daughter Lydia just weeks into his presidency. Deborah has done battle with and is now recovering from breast cancer. Both of them have borne this last year with fortitude, dignity, and great courage. Their commitment to APIL never faltered. We are immensely grateful for their service. Lastly, I want to thank the good people on the APIL staff in Nottingham. Their loyalty to the organisation and good counsel has seen us through the last 25 years in grand style. Thank you all. But having said all that, this time next year, I don't want any of the staff to be working for the organisation. I want them redeployed in good jobs elsewhere. I'd like to see an empty hall here at the Celtic Manor in April 2016. I would like to see everyone here, in fact all our members, working not in PI, but other areas of the law, maybe conveyancing or crime, or helping corporate clients avoid their tax bills. Chris Grayling, should he still be in post this time next year, will be sipping champagne, pleased as punch that APIL, that thorn in his side, has closed its doors. Think about it. We wouldn't be needed because no one would ever be harmed as a result of the carelessness, recklessness, or downright criminality of another. That, ladies and gentlemen, is my idea of utopia. We would no longer have to interview people whose lives have been shattered by negligence, maybe facing an untimely death or a lifetime of dependency on others. Nor would we regularly meet those whose loved ones had been taken from them or whose childhoods had been stolen through abuse and neglect. And this is where my utopian view falls down. Because despite the fact that preventing needless injury is a laudable aim, it's also a pipe dream. It's never going to happen. And that's why we need APIL. That's not just the we in this room, or all our members, or all injured people, but society as a whole needs APIL. APIL is needed to stand up for everyone who cares about the fact that justice is being eroded by the powers that be. Those of us here today are the ones who are still here to tell the tale. I know that the last few years have been tough for our members. Personal injury litigation has become a political football, a punch bag. Anyone, it seems, can come and have a go, like those heroes under the Sarah Bill. We have reeled with the punches, but we have survived. To survive, we have had to change. But change is not a dirty word. Change can be a force for good. It can make us brave. It can make us dynamic in how we do what we do. And this is what I want to talk to you about today. Injustice, change, and the kind of lawyers we need to be for the future. As this is our silver anniversary, you'll forgive me if I just take a moment to reflect on some of our campaigning work in the past. We have made significant achievements, sometimes alone, sometimes standing shoulder to shoulder with others. We helped to secure a fund of last resort for mesothelioma victims who cannot trace their employers' insurers. APIL should be very proud, as this had been a long time coming. We argued, of course, for the fund to cover other long-tail disease victims too, and I accept we didn't succeed on that. But the meso scheme is a great one on which to build, and we will continue to campaign in this area. Our commitment to rehabilitation from the very earliest days led to the Rehab Code. APIL's Rehabilitation Handbook is recognised as being the definitive guide to best practice on all sides. We have adapted and improved on that initial work, and I'm delighted that we are launching the third edition at this conference. Very recently, we helped to defeat the Medical Innovation Bill, which would have put patients at risk from rogue medics. We have been involved in battles of long ago too. We successfully campaigned for the cap on damages in both the Montreal and Athens conventions to be lifted. And for every increase in bereavement damages 3 times since 1990, APIL has been there, arguing for the increase and ultimately getting the government to act. Of course, our work on bereavement damages seems to be never-ending and continues to feature heavily in our campaign priorities even to this day. We do remain true to the ideal of our founding fathers that APIL's first aim is to promote full and proper compensation for injured people. Despite the cost wars, so-called whiplash fraud, the compensation culture, and any other number of sideshows, it's the plight of injured people and their ability to access justice which continues to concern us. But perhaps our greatest achievement is that 25 years ago, APIL brought together claimant lawyers to share knowledge for the benefit of their clients and injured people everywhere for the first time. This had never happened before. Let's face it, we were then and we are now still in competition with each other. Mike Napier, a founder member and past president, has said that this breaking down of barriers between claimant lawyers was one of the biggest challenges for APIL, and I believe it has to be seen as its biggest success. Bringing together a fairly diverse membership, but an authoritative one, to fight for the rights of injured people is our power and begets our influence. Since we were formed, we've been involved in pretty much every battle ever since on behalf of injured people, and we're almost always at the table. In terms of law reform, we've provided injured people with a voice. We've won many skirmishes and many battles, but I accept we haven't won the war. With a general election around the corner, I have to say that the legacy of this government is shameful when it comes to looking after its citizens' rights, including their right to compensation. I came into this business to be a legal aid lawyer. I was personally, politically motivated to represent those who did not have the means to obtain representation themselves. Whilst our clients must now have skin in the game for the claims they bring, and for most practitioners, legal aid is a whimsical memory, our clients are at least still in the game, with representation. Let us spare some thoughts, please, for our colleagues undertaking criminal legal aid work and family law cases. The court system is creaking under the strains of having to accommodate litigants in person. Some real injustice is being done because the government has been allowed to raid the coffers. People are at risk of losing their liberty and losing their children because they cannot afford a lawyer, and many lawyers can't afford to operate in a system which puts such a low price on their skills. For us, the LASPO Act brought into being the Jackson reforms, not wholesale, a few cucumber sandwiches short of a picnic perhaps, but more or less. The impetus, we were told, was the need to drive down the costs of litigation. That was the rationale behind the changes, and I can understand that. It's logical at least. It even has some principle behind it. But then, just last month, the government announced it was putting up court fees by as much as 600%. Where is the principle in that? That is increasing the cost of litigation. They call these enhanced court fees. Enhanced means improved. What kind of Orwellian doublespeak is being used here? This is nothing short of a tax on our clients' misery, which it is passed on to us to pay for. No justice system should be run for profit, and enhanced fees shame this government. The Scottish Government is consulting now on its own LASPO, the Expenses and Funding Bill. This proposes to bring many of the recommendations from the Taylor Review to the statute book, and as you will expect, APIL will be subjecting the rules to scrutiny. Is the Scottish Government legislating from principle? And will there be sufficient resources to ensure that the rights of the injured will be protected? Watch this space. LASPO is not the only insidious piece of legislation that I can point to. The Criminal Justice and Courts Bill received royal assent just 2 months ago. This act requires the courts to be hyper-vigilant in every case to dishonesty on the part of a claimant in PI claims. If a claimant pursues a claim which is ultimately decided to be fundamentally dishonest, he or she is denied any damages whatsoever. What fundamentally dishonest actually means is anyone's guess. Note, of course, that fundamentally dishonest only applies to claimants. What about defendants who pursue fundamentally dishonest defences? Who say they haven't got crucial documents to disclose when they have? Who defend a claim for child abuse against a priest by claiming that at the age of 15, my client consented to being raped by a 61-year-old man of the cloth? Is this an honest defence? How can it be? Not least because the Catholic Church insists that all its priests are celibate. Taking instructions from my client, now aged 20, on such a pleading, signed by a senior official of the church into which he was born, was almost unbearable. I truly wonder whether people outside this room, the people who are making this stuff up in court documents for the defence, have any idea what sort of thing this does to someone. How about the defendant who purposefully sets out to delay a settlement brought on behalf of a terminally ill claimant because it would be cheaper to pay out on the claim when they are dead rather than alive? What about a litigation authority that spends vast sums on defending the undefendable, costing the taxpayer thousands when it should have apologised and put in place a meaningful rehabilitation programme to help a claimant's recovery? Isn't that dishonest? Why aren't such defendant practices also caught by legislation? Just last month, Mr. Justice Phillips presided over an attempt by defendants to have noise-induced hearing loss classified as an accident rather than a disease. The case was Dalton and British Telecommunications plc. The point of this rather esoteric argument was to save the insurance industry money in not having to pay out disease-scale success fees for deafness claims. The judge was clear that through their arguments, the insurers were not only trying to misrepresent what Parliament had originally intended, but also renege on an agreement made back in 2005, which they had fully supported at the time. Opportunistic, the judge called it, doing the defendants little credit. I call it downright dishonest. The Criminal Justice and Courts Act also changes the way that judicial reviews will be dealt with in the future. The Act allows the government a get-out-of-jail-free card because if, even though it is done wrong, the outcome for the applicant would not have been substantially different, then relief should not be granted unless there is some other exceptional public interest. More new phrases which have no immediately discernible legal definition. And because of the celebrations for APIL's Silver Jubilee, you may be forgiven for missing another rather important anniversary this year. The Magna Carta was signed at Runnymede on the 15th of June, 800 years ago. To no one will we sell, to no one deny or delay right or justice. No less a figure than Lord Denning described Magna Carta as the greatest constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot. How ironic, then, that in this year, this government is misusing its power to bring about changes to our civil justice system which will be of direct financial benefit to itself whilst the rule of law is ignored. If legal rights are eroded, who cares? Almost nobody, it seems, until they need them. Personal injury lawyers are a distress purchase that people never think they'll need. It's not like the NHS. We all expect to have to use that sooner or later. Most, if not all of us in this room, have relied on the NHS in the past for something, even if it's something very minor compared with our clients' experiences. We know we all want the best medical care when the need inevitably arises, and we know that people care passionately about the NHS, and rightly so. But in my mind, access to justice should be just as important, if not more so, to the citizens of this country. We need to make more consumers, parliamentarians, opinion formers care about what is happening to our justice system, a system that is being dumbed down, sidelined, and in some cases dismantled completely. Here are some examples. The Department for Justice in Northern Ireland proposes to close 40% of the courts, which are already stretched due to an increase in the county court jurisdiction. Think of the outcry if the Department for Health decided to close 40% of the hospitals. We ask, how will the court system cope, and why is access to justice so low down the list of priorities? Did you hear that they're replacing judges with legal assistants to make judicial decisions at the Salford Business Centre? This is a pilot scheme which will run for a year from October. What are the implications of that? Thin, end, and wedge are words that spring to my mind. If Richard Susskind and his friends get their way, we will have artificial intelligence deciding damages and disputes. Who would have thought that Lord Justice Dyson could be replaced by a clever vacuum cleaner? And online dispute resolution, taking its inspiration from eBay, you might as well outsource justice to Ladbrokes. What can we do to stop the rot? Well, I think APIL members can do much. I have already spoken of the fact that APIL's greatest success was in getting claimant lawyers together to share their knowledge. By joining APIL, members are committing to a higher ideal than just making money for their firms. Yes, we must oppose anything that erodes access to justice for vulnerable people. And I know all of you, believe passionately in that. But we must also look for and embrace changes which make the system more efficient when it brings clear advantages to our clients. I want to say this at this point so there is no misunderstanding. I am proud to belong to a profession, and I do still believe we are one, which for me embodies high standards of ethics, integrity, expertise, and trust. But the word profession does have connotations too, of being old-fashioned, reactionary, and protectionist. And those are not features of any profession that I belong to, at least not today. And I think society is better for it. The SRA has dictated that we no longer need to record compulsory CPD hours. As a profession, that must not mean that we should relax standards, we should raise them. We really must raise the bar, keep on learning, keep working towards being professionally accredited so that injured people know exactly what they're going to get when they have to make that distress purchase. And if there ever was a business case for joining APIL's accreditation schemes, then it's this. It gets you noticed, it gives you the edge. I accept the need to innovate in the work that we do and how we deliver it to enable us to continue to serve our clients effectively and in a way that works for them. We can do this. We have taken everything that's been thrown at us and we're still here. I always think of Rudyard Kipling, if you can keep your head when all about you are losing theirs. We have kept our heads and will keep them yet. APIL can help you know what's coming, what you may have to do to adapt, change, stay ahead of the game. There is still a place for specialists and for high standards, and APIL champions this. Our members clearly shouldn't be dabbling in areas unfamiliar to them, but APIL can help members retrain. We are, after all, the leading training provider in our industry. Through our corporate accreditation scheme, we can support your businesses too. Let's be progressive, let's keep our ideals pure and our approach ethical. The injured people we serve deserve no less. So, with that in mind, what are the priorities in my presidential year? Well, a huge part of our campaigning time will be spent in fighting for full and fair compensation for injured people. We will continue to call for reform of bereavement awards and compensation for psychiatric injury. We know that there's a postcode lottery out there. It's better for your loved ones if you die in Scotland rather than England and Wales. That is, frankly, ridiculous. Bereavement damages are an insult in this country. You've heard us say this before, but how can it be cheaper to kill rather than to maim? And talk about a postcode lottery. In Northern Ireland, bereavement damages are still stuck at £11,800. You would think that the case for reform there is unarguable, and you can bet that APIL is doing its best to make that case. Damages for psychiatric harm for secondary victims were predicated on cases that came out of the Hillsborough disaster 26 years ago. The vast majority of us didn't have mobile phones then, let alone social media and the World Wide Web. Legislators need to look again at issues of the closeness of the relationship to the primary victim, proximity to the event, and at how the news is received. The law has to be brought up to date. Part of APIL's mission is to prevent needless injury. We will continue to press for an end to the misery of pressure ulcers in the NHS and care homes. 95% are preventable with decent care, and treating them costs the NHS £1.8 billion a year. Think of the savings which could be diverted to treat cancer victims with the latest drugs, to provide more beds, more doctors, more nurses, if the NHS just got that one thing right. I know that the NHS has recognised the problem. They assure us that they're committed to tackling it and have already made some progress. APIL will be monitoring their performance during my presidential year. I will be involved too in a project with the Advocates Gateway to promote awareness of the plight of vulnerable witnesses in court. We will produce a toolkit for court users, judges and advocates to follow, helping vulnerable witnesses give their best evidence in civil disputes. Now, I was inspired to get involved because of a lady called Frances Andrade. Let me tell you her story. Frances Andrade gave evidence at the criminal trial of her music teacher, Michael Brewer, in January 2013. Brewer was charged with raping her on numerous occasions when she was a child. Brewer's counsel in cross-examination persisted in describing Andrade as a liar and a fantasist. After the trial, Andrade told a friend that her ordeal at court was like being raped all over again. Hours later, she committed suicide. She didn't live to see Brewer convicted of the crimes against her. Now, I represent survivors of child abuse in compensation claims. Often my clients have already undergone a bruising experience in the criminal courts. Many will come to me as damaged individuals with long-standing psychological problems. It is difficult, if not unpalatable, to know that the very process I use to help my clients obtain their rightful compensation is also a means of their torment. As officers of the court, I feel it is our duty to ensure that our justice system, whilst remaining robust, is not abusive to those who participate within it. There is much I feel we can gain by engaging with all sides to make other improvements to our civil justice system, cooperating in dealing with serious injuries, rehabilitation, and mediation. Controversially, perhaps for some, we will also be working with the government on its reform agenda, with APIL representatives sitting on the Medco and Portal boards. With 25 years' experience of campaigning and lobbying comes the certain knowledge that it is better to be inside the tent, influencing the debate, rather than outside, where we may be shouting, but where our message falls on deaf ears. We are looking too at reform of the insurance industry, championing the idea of compulsory public liability insurance. Claimants denied redress because a defendant has gone bust without insurance is a real issue, and we can call upon a body of clients who will speak of this injustice. Some rogue business owners liquidate their companies to avoid paying out and then set up a new business and carry on trading with impunity. This is morally unacceptable and should be tackled head-on. Compulsory PL insurance would also have the added benefit of driving up safety standards among public-facing businesses. This needs serious consideration at the highest levels. APIL has the power, the reach, and the influence to start the debate, and I intend to make sure we'll be listened to. We'll be listened to because APIL is the expert voice of thousands of claimant PI lawyers and the millions of people they represent every year. We are vital to the effective administration of justice in this country, vital to holding the government to account to ensure it upholds the rule of law. We are vital to righting the wrongs done to injured people. Let's get on and do just that. Thank you.